Good afternoon, everyone. I have to put headphones on today. We have some construction going on, which is very noisy. Welcome to our community conference call every other Thursday. Today is April 29th, 2021. I am Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Hopefully you can hear me. Let me double check because I'm using a new headset. Just give me 1 second. Let me check.
The conference is now in conversation mode.
Can you folks hear me okay? Hello?
Yes, Rajiv.
Excellent. Thank you.
The conference is now in presentation mode.
So as usual, I have marked some of the questions as frequently asked questions. Everything that we discuss is subject to the disclaimers you would have heard when you logged in. The first frequently asked question is options for potential H-4 dependent visa holder continuing their employment in their home country, which in this case is India. So a lot of this discussion actually holds true for many types of visas, not just H-4. It could hold true for even primary work visas. Okay, so just be aware of this generally. I'm currently on H-1B in USA. Girlfriend and I are planning her move to the US after marriage. She's currently in India working for a California-based big tech company, and she will try for an internal transfer on L1A, L1B, but it might not work out. The alternate option is to come to the United States on H-4 and use H-4EAD. That would require her to continue her employment in India. Not really. I mean, you don't want any interruption, but what you're saying as though the law requires, the law does not. But if you prefer to do an H-4EAD and then go back to India, let's look at the options. Can she stay and work in India while on H-4? Absolutely. Almost every visa, including H-4, gives you the option but not the obligation to be in the United States. So there's no law that says just because you have an H-4, you have to come to the United States. You could get the visa and stay right back. Number 2, does she need to leave her job in India if she wants to travel to the US on H-4, or can she just apply for leave without pay for the time she's in the US on H-4? She can definitely apply for leave. The law is she should not be working, in the way I look at it, on the US soil. I'm sure there are people who disagree with me, who would say that, well, if the job is not open to US workers, how should this be problematic? I just think it's a risk that is not needed. So if you believe that even though you're working for a company in India and you are working from the US soil, it's okay to do so, I don't think it's a clear-cut answer. So I prefer to avoid those situations. But can she take leave? Absolutely, because she's not working. If you get paid without working, or if you work without pay, either of those situations could be considered to be not employment under US immigration laws. So working without pay or getting paid without work, by the way, if you find that job, I want it too. One thing you've got to remember is that working without pay means you should not be getting benefits either if you are working. So if you work for benefits, that's also unauthorized employment. But if you are not working, like you're on leave, and you're still getting your benefits, that's okay. Another kind of payment that's okay is for money that you have already earned. So let's say you worked for your employer all through the last year, and this year, while you were on leave, they paid you bonus for the work you did last year. That's perfectly okay. Okay, and that's also true for H-1 holders in the United States. For example, an H-1 holder goes from employer X to employer Y, and they've been approved for the transfer. While they are working 3 months later, employer X says, oh, by the way, we owe you $10,000 for travel allowance from last year. And that's okay because that's money you already earned. That's not unauthorized employment. Okay. So I hope that answers your questions. If anyone has any follow-up question, press *5. No new questions. Press *5 on your phone. *5. Okay, let's go on to the next frequently asked question. We have one that is extremely important. Oh, perfect. It came up. So the question is, can I apply for a green card while I'm on a student visa or OPT or STEM OPT? And the answer is yes, but the problem with F1 visas is, under the current laws, upcoming laws might be different, but under the current laws, you cannot have immigrant intent while you're on student status. If you do, your visa can be revoked and your entry into the United States can be denied. So that means if you were to travel outside while the green card was pending and you were on F1 visa, you would have a problem. If you are from a country that doesn't have a huge visa backlog, that might be an acceptable risk. Why? Because you could be done with your green card even under the PERM process within a couple of years. But if you are born in India or one of the other backlog countries, you could take 10 years, 15 years to get your green card. And doing it on a student visa could be problematic. Of course, you ultimately, once you get onto the H-1B, that problem vanishes, right? So the difficulty is filing the green card introduces the idea of immigrant intent. By the way, another interesting point is immigrant intent does not begin when you prepare to file the PERM. That can take 5-6 months. Immigrant intent is not exhibited when you file the PERM. Preparing for the PERM, filing for the PERM, waiting for the PERM, none of it is immigrant intent. But the moment you file the I-140, that's immigrant intent. So any proceeding in which you have filed the I-140, whether under EB-1A, EB-1B, PERM-based cases, national interest waiver, you are exhibiting immigrant intent. And that becomes a problem for a student visa. Any benefit under student visa that requires you not to have immigrant intent, such as travel outside and coming back into the United States, could become a problem for you. So you can apply, but if you are born in a country that's heavily backlogged, make sure you understand what you're getting into. Of course, let's say that you're born in India, you're waiting 15 years and you keep trying for the H-1B lottery. In the year 4, you get your H-1. You can travel now, no problem. Okay. So let's see there were 2 sub-questions here. 2 individuals had posted this. Another one was, my country of birth is Nepal. Yeah, so Nepal is not India. It's not the citizenship that matters. So Manu V, which is right, his name is right here. I merged these. Manu said, I was born in Nepal, but I'm a citizen of India. It is the country of birth that matters. It is not the country of citizenship. And by the way, you can also use your spouse's country of birth to take advantage of this. So if you were born, for example, in India, but your wife was born in Kuwait, you would be charged to Kuwait through a process called cross-chargeability. So if your country of birth is Nepal, you will be under the Nepal quota. Okay. So this can work for you. Do discuss it with your lawyers, but I don't see any problem with it. *5 if you have a follow-up question. No new questions. *5 if you have a follow-up question. By the way, today I had asked the team to keep the number of questions low, 10 to 12. They were putting in 17, 18 questions. That made it impossible for me to take my time about the questions and also to answer any new questions. So today we'll have time, hopefully. I don't see any problem with finding time for additional and new questions. Okay. I'm going to go on to the next frequently asked question if there is one. Okay, there isn't one. Good. So we can now go back to our regular questions. Our regular question number, wait, what am I doing here? A regular question, oh, this was the first frequently asked question. So, Vicky had a problem. His employer made a mistake when filing the 485 for his wife. Instead of filing the right category, they chose the wrong category, which is EB5. So the 485 for her, or maybe him, the spouse got denied. The service said that they will take care of it during adjudication. Now the question is, how do I make sure that the USCIS has accepted this correction and it's not going to become a problem 4 or 5 years down the line? It's very difficult to be assured of that, sir. Extremely difficult. The only way you could confirm that probably is if you went through a congressman's office, and that's a good way to go. If you guys need a link to how to contact your congressman's office, we have a small write-up. You can send me an email. I'll send you the link to that document. It explains to you how do you find who your congressman is, how do you contact them, and the kind of things you can ask them. So what happens is, if a congressman says to the USCIS, has this correction been made and is this going to be a problem, they have to respond much more responsibly than they will respond to you. Okay? So I would say a congressional inquiry is as close to a good way to go as can be. Another thing you can do is, when the date becomes current, file 485 again for her. Okay? *5 if you have a follow-up question on this. Alright. So this is from area code 801. Hi, 801, where are you calling from?
Hi, Rajiv. I'm calling from Houston, Texas.
Yes, sir.
So a follow-up on the same question. So let's say if the derivative whose 485 is marked in the wrong category and still being receipted, it was receipted, let's say it was receipted by USCIS, if they use EAD and AP and 4 or 5 years down the line, when the final adjudication date comes, if USCIS creates a problem, what can be done about that?
Okay, first,
should they be using the EAD based on this, or should they not be using the EAD? Or
first of all, if the case had been receipted, chances are you're okay. That's another indicator, good indicator that you're okay. Double checking through the congressman's office creates a lot of reassurance. That's also a very, very good idea. Okay. Now, let's say 4 or 5 years down the line, when the dates become current, if they try to deny her, she will not be entitled to file a 485 unless she has also maintained her H4 status. If she has maintained her H4 status, then if the 485 is denied and the dates are still current, she can file another 485. Okay?
Okay. Thank you.
You're welcome. Good luck. Okay. Next question. So this is a weird situation where the employer, H-1B employer, says, look, I'm going to give you, let's say, 60% or 70% of your salary every month, but at the end of the year, I'll give you the remaining money, bringing it up to your LCA wage as bonus, which is about $23,000. Now, the problem with this is H-1B laws say your base salary, which is indicated on LCA and H-1B, must be paid in equal regular installments, whatever they are. If you get paid bi-weekly, you must be paid bi-weekly, monthly, you must be paid monthly. They can't have these fluctuations. So if your basic salary is $63,000, it's got to be paid in equal installments. So that's a violation, but that's not a violation held against you, the employee. That's a violation held against the employer. But if you try to change status, or if you try to transfer employers, government will say, oh, wait a minute, you're not getting paid enough. Having a wage and hour division complaint would certainly help you, because that means you'd complain to the Department of Labor that I'm not getting paid in regular installments. And that's a good reason why you don't have your full salary. Definitely having a wage and hour division complaint helps in those cases. Otherwise, yeah, you could get an RFE. You can join your new employer as soon as you get the 797 receipt, or maybe even earlier as soon as it is filed, but definitely as soon as the receipt comes. And we've had this situation about the H-4 visa already been filed. I was advised at least a few weeks ago by the USCIS that you should go ahead and file another H-4, because otherwise it can get messy. When they withdraw the H-1, the H-4 will also get withdrawn, and that can create a problem. So I think it's a good idea to just file another H-4. *5 if you have a follow-up question. *5. Okay. So somebody's re-entry permit is expiring because of the pandemic. And the question is, can we file a re-entry application through the consulate? And the answer is no, because the re-entry permit is adjudicated by the USCIS. It can't be filed from outside the USA. You have to be inside the US. Will I get another 2 years if I apply? So technically, the government gives you 2 years the first 2 times, and then they should drop it to 1 year. But they often don't do that. Often you might keep getting 2-year extensions. *5 if you have a follow-up question on this, Arjun. Press *5 on your phone. Okay. Area code 917. 917, are you in India?
Yes, Arjun ji, sir, Rajiv ji, this is Arjun from India.
Yes, sir.
Can you hear me? So, right now, Rajiv ji, there is some travel advisories from people traveling to India from the US.
Right.
And with a lot of rising COVID cases in India,
right.
I'm just trying to think through, even if I come there, take a ticket, or will have any challenges in terms of, because what I did in 2019, I came there for 3-4 days and mailed the application.
Mm-hmm.
Then I got a biometric appointment, which I came within 2 months.
Mm-hmm.
This time, with pandemic and my re-entry permit expiring in 28th June 2021, and right now it's cases are going peak. I'm just trying to think through what will be the consequence of traveling to the US from India.
Well, first of all, last time you filed the application while you were in the United States, right?
But actually, I was in India, but I came to US just to file.
That application.
When I went back to India, I then came back.
That application should not have been granted. Okay, so they made a mistake in giving you that re-entry permit. Can you do anything about it now?
Why, Rajiv?
Because you have to be physically in the United.
I was in the US.
Sir, you have to be physically.
I was in the US when I filed my.
That's the question I asked.
I was in the US when I filed.
Yeah, that's what I asked you.
Okay.
So what you can do, just as a general rule, once you file the I-131, you can take a trip out and then come back for the biometrics. Once you do the biometrics, then you don't have to stay. You can leave. And the re-entry permit can be sent to a consulate close to you in India, or to a friend or family member in USA or your lawyers, and they can forward it to you. But now when you apply, you have to come back.
Okay.
So when does your current re-entry permit expire?
June 20 this year.
June 20, 2021, right?
Yeah.
Okay. So if you are not able to make it before then, your green card will be deemed to be cancelled. You will have to try to contact the consulate and apply for returning resident permit, also called SB1 visa. Okay. Now, for that, you'll have to establish that you never intended to leave the United States permanently or for long term or indefinite basis. Things just worked out like that, and this time you couldn't return because of the pandemic. So SB1, either you come back and apply for a re-entry permit, or you can take your chances with an SB1. Now, one of the things that's very weird, see, normally when you try to board a plane with an expired 131, the airline should not issue you a ticket. They will not let you board because they are also liable for fines if they don't review your paperwork properly. Last month, or was it earlier this month, the Customs and Border Protection issued an advisory to all the airlines that as long as somebody has an unexpired green card, let them board. We don't care how long they were outside. Okay. So the idea would be, I can only guess, that they will be allowed to travel, people like you. When you come to the United States, you'll be questioned closely and long at the airport. Okay. So this is just something for you to remember. As far as your next step is concerned, try to make it back before June so you can get your re-entry permit done here.
Okay. Yeah, that's my original plan, to come before June and mail the application.
Yeah.
And again, come back in a month or two for the biometric.
Right.
And one more thing, when I was reading online, since I took my biometric in 2019 May, there are chances they may consider my older biometric in 2019 May and may issue a
don't
re-entry
know.
permit, right?
I don't know that they are doing it for re-entry permits, but it makes sense logically. Your fingerprints don't change. You're the same person. So I don't know what they are going to do. I can't predict.
Okay, got it. And the SC one is what you mentioned, right? That is only in case I can't travel before June 20.
Right.
Which is the date of experience of re-entry permit. Then only I have to apply for that, right?
That's right. That's right.
Okay. And Rajiv, just this personal question. So I've seen recently people coming from India to US with rising and getting allowed in as long as the vaccination is done, they can still come. They don't have to get quarantined in the hotel or the airport. They can still go back to.
Okay.
Is it happening? Are people coming from?
Oh, I have no idea.
People coming from,
the COVID-19 situation is something I don't keep track of. I take care of the legal side of things because the COVID-19 situation is changing rapidly all the time. What you should do is always trust the cbp.gov website, Customs and Border Protection. And the second one is the cdc.gov, Center for Disease Control. These are the only two sites you should trust.
Okay. I'll go through it. And one more thing, is a related thing. So I also got my N470 approved in 2018 because I work for subsidiary of US-based company.
Right.
And this with the current changes, I may go for a different subsidiary of US company.
Okay.
A lot of changes happening in India.
Okay.
When I got N470 approved, the approval form says it's approved for infinite time as long as I work for the same subsidiary or same US company.
Right. I don't know the answer to your question. I don't know if you have to do another N470 or whether the same N470 is good for the same group of companies. Somebody should look it up. I don't know the answer off the top of my head. Okay?
Sure. Definitely. Thank you so much.
You're welcome.
For your
Good luck.
response.
Good luck, sir. Okay. So then comes, you already did this. So one of the questions, which is question number 7. Oh, somebody else just raised their hand. Can you please raise your hands at the time when I'm asking the question? Because otherwise we are all over the place. Where are you calling from? Good afternoon. Hello.
Hello.
Yes, sir.
Sir, I'm calling from India.
Right.
May I ask you a follow-up question?
Follow up to what question?
A follow-up to the question that the gentleman asked currently
For
about the re-entry permit.
Yes, sir. You can. Please go ahead. Please go ahead. I have come back to that
sir,
question. Yeah.
I heard you saying that.
Go ahead.
Sure. Sir, I heard you saying that we can travel even if we have stayed outside for more than a year.
Yeah, that's.
Is it too risky?
Is it? See, the problem is, oftentimes this government gives only incomplete statements. It's much better than the last government, but it's still not where we want it to be. So, this statement or these instructions were given to the airlines, to the air carriers. When we looked at them, the decision actually, I think I was quoted in the Times of India about this. My conclusion was, what they're saying is, come on in, and when you land at the airport, we will examine in detail your case. Okay. That's the way I read it, because there can be no other conclusion. Otherwise, why would you exempt the airlines from document examination, which has been a part of their duties for decades? So to answer your question, that's how I read it.
Okay.
All right. So,
yeah.
another thing
thanks, sir.
Another thing you can do, if you don't want to take a chance, you can actually, or take less of a chance, you can actually land or get your immigration clearance done at any of the 7-8 immigration pre-clearance centers, which is closer to India than the United States. Because if they deny you entry in USA, you've got to fly back 20 hours. But if you clear immigration in Abu Dhabi or in Ireland, it might be so much easier to fly back, right? So just keep that in mind also. Okay?
Sure, sir. Thank you.
You're welcome.
Sir, I have another question, but may I ask it at the when you open for new questions?
I'll open it for new questions. Stand by. Okay?
Thanks, sir.
Yeah, I'm just going to finish the posted questions first, and we should have at least 10-15 minutes to do new questions, maybe even more. So let's go to... so this was the question that I was going to answer. Which is better, H4 EAD or F1 OPT EAD? They both have their pluses and minuses. I don't like the fact that H4 EAD is taking so long. F1 OPT is also taking long, but not as long as H4 EAD. The problem with OPT is that you've got to work at least 20 hours each week, first year OPT. It can be paid or unpaid. The good thing about H4 EAD is you don't have to work if you don't want to. You can work 10 hours if you want to. You can start any business you want to. F1 OPT, you can start a business, but it's got to be in your own area of major. So if you're a computer science major, you can start a computer science type business. Okay. They have their pluses and minuses. Which one is better to get H1 visa? They are the exact same. As far as getting H1 visa is concerned, there is no difference. Okay. And it shouldn't matter that much at this stage whether she's on H4 or F1 for your green card process. But do talk to your lawyers, make them aware. If she's on F1, they'll have to plan a little bit around that. Okay. Star 5 if you have a follow-up question. I have a follow-up question again from India, it looks like. You're going to have to wait. I think it's the same gentleman with the re-entry. Please don't do that. Please don't. Just ask your question at the same time. Go ahead, India. How can I help you? India?
Rajiv, I'm sorry. You mentioned about...
Yeah, see, this is very disruptive. I like to group the questions together so that they make sense to the people who are listening. It's very disruptive. So I'm not going to do that again. Guys, keep your questions together, please. Go ahead, finish up your question.
Yeah, so you mentioned that we can do immigration even in Abu Dhabi and Ireland instead of coming to the US.
Mm-hmm.
So I did not know that. I thought only immigration can be done only in the US.
No, there are immigration pre-processing centers. I think there are 8 of them.
Okay.
Okay.
Okay. So you have to take a flight through that.
Yeah, basically, yeah, exactly.
It can be done there.
Exactly.
Okay.
Okay.
Got it. Okay. I'll Google it up.
Oh, yeah.
Okay, thank you.
Good luck, sir. Okay. So. Oh, I'm sorry. Did somebody else have their hands up? Yeah. Area code 562. Go ahead. 562. Go ahead. Oh, maybe I didn't. Hang on. 562, California. Go ahead.
Yes.
Go ahead, please.
Hello, Rajiv sir.
Hello, sir.
So I had a follow-up question regarding this H4 EAD versus F1 OPT.
Good. Okay.
So first question is, with this H4 EAD, I know currently it's taking a long time. Like it's like taking, like, first of all, when it goes to extension, it's taking a year just for the extension, and then for EAD is there, then again it's like almost a year.
Right.
Do you see this delay will be reduced when this COVID is going to be cooled down, maybe with this new government? Do you think any benefit will happen to H4 EAD, like the
I think so.
process, or they can work on?
I think so. I think some of it is politics and some of this is inefficiency. But with President Biden,
right,
I feel that the country is back on track. We don't have, look at the way the COVID shots have been given. Within 3 months, 50% of us have at least received 1 shot. Under Trump, he was saying, drink Lysol, you'll be okay, or drink Clorox and you'll be okay. What an idiot. So in any case, we are back on track, and I'm hoping that things will be a lot better now. So eventually these things should work out.
Okay, sure. And the second question is regarding the future of, like, the green card. So currently my I-140 is approved. So does that mean my wife's green card petition is also in progress? Can you say
Yeah, that's what
no?
I have researched this issue very carefully, and I've looked at the I-140 instructions. I've looked at the question, the particular question that says, has anybody filed a green card for you? In my view, if you have been named in an I-140, I think you have exhibited immigrant intent. That's my conclusion. Okay.
So if you have mentioned that in the spouse details, if my wife is there, then we have intended that.
That's my conclusion. There are lawyers who disagree with me. I think they are wrong and they think I'm wrong. So far, I'm not aware of any decision from the USCIS that says one way or the other. And remember, when in doubt, over-disclose. Don't under-disclose. Okay?
Okay, sure.
Good luck, sir.
Thank you.
You're welcome. Okay. So, this is another interesting question. I've answered this many times. It's in our frequently. I am not going to take questions out of turn, guys. I'm not going to do that. Sorry. Wait till the end. Entering the US on a visitor visa with I-130 petition. So, do look at the frequently asked questions we have posted. Many of these discussions have been taken up many times. So, if you have a green card pending, you may or may not be allowed to be in the United States on a tourist visa. Some people have been allowed, some people not. So you can try again, go to one of the pre-processing centers, immigration centers where you don't have to come all the way to USA. Okay. The second part that you asked me about filing the I-485 once easier, that's tricky, and I have covered that in detail. You don't want government to draw the conclusion that this was visitor visa being or tourist visa being misused, in that you had the intention to apply for an adjustment of status. So they can call it fraud, and they have done that. Trump administration. Before Trump administration, usually immediate relatives of US citizens didn't have that much of a problem with this. Now they say if you file for adjustment of status within 90 days of entry on tourist visa, we consider that presumptively to be fraud. Okay. What happens after 90 days? They can still question it. The bottom line is you should not have that intention to apply for adjustment of status when you enter the United States. Can you change your mind later? Yes, you can, but it's still tricky. Listen to the frequently asked questions we have posted on this. *5 if you have a follow-up question. *5. Okay, I'm putting down the hands that were already raised so that when we come to new questions, you can raise your hand again. Okay, so approved I-140 and change of employer. My I-140 has been approved since 2011. EAD is pending, 485 has been pending for 180 days, but I don't have the EAD yet. Can a new employer file for my H-1B? Yes, absolutely. Do I get to keep my pending 765 and 485? The answer is yes, because your I-140 is approved and your 485 has been pending 180 days. Will I have to redo perm and I-140? No. And you will keep your priority date if you wanted to redo it. And even if you did not, you can port your job over to the new employer as long as the job is same or similar. Same or similar includes promotions. So if you went from being a software developer to a software program manager or a delivery manager or some kind of a systems manager, that would be a promotion and probably would be considered same or similar, but your lawyers should help you decide. The new employer will have to file a supplement J for you. A supplement J, I-485 sub J. Just make sure they understand. *5 if you have a follow-up question on this. *5. Alright. Let's do the last posted question, which is, let's see, the last posted question. I'm not sure what this question pertains to, because there is a little bit of a confusion here. You did something in a Canadian university, but you didn't study it. Do I need to mention my 4 months of... I don't know what the DS-160 asks. So if the DS-160 wants to know about your Canadian immigration or Canadian studies, you should answer it. If it doesn't, you don't answer it. That's not something I can really help you with. And we also can never help you fill forms. Okay? We can answer generic questions. Most forms, when we fill them, require that we sign at the bottom of the form. Okay? Can't help you fill forms. Okay, I'm going to again put down, there are some more people who have put their hands up. I'm going to put the hands down. Now, any questions at all, press *5. Any questions? Press *5. Okay, so that's not too bad. We just have two people. Oh, that's easy. Anybody else, guys? Make sure. Please don't do it at the last moment. Okay. So we'll do 2 questions that are left. Very good. So the first one is from area code 614. 614, where are you calling from?
Hello, Rajiv. I'm calling from Ohio.
Yes, sir. Go ahead.
Yeah. My first question is, if I have an employer with a job offer, and my priority date from an old I-140 is very close, and especially that it, in the upcoming year, I would be eligible for filing. It seems, so in that situation, since the employer is ready to wait, what would be a better route in terms of, because they said that they're fine to directly sponsor me a green card and have me on an EAD whenever the date becomes current, versus actually doing it, is an H-1B required first to be done by them to file a permanent I-140?
So let me understand the question. The question is, your I-140 date is coming to be current. Remember, if you change employers, you can't file 485. You cannot. Okay?
Correct.
So
right. So the new employer will do the entire permanent I-140. Correct?
Okay. So is that possible, advisable, etc.? And the answer is sure. If your job is such that it's in short supply and high demand, and so it's an easy labor cert perm, I would do it. Absolutely. So do they have to do an H-1B?
Okay.
They'll have to do an H-1B because 485 is not filed. You don't get EAD without a 485.
Correct. But if they, what if they are ready to wait until the 485?
I would actually like that better. Okay. I would actually like it if 485 was filed and ideally you waited 180 days after filing the 485. Hopefully by that time you get the EAD. Now the $1 million question is, my 180 days are over. I-140 is approved. 485, EAD is in hand. Okay. Do I still need an H-1B from a new employer? And the answer is, I prefer it, but it's not required. Why do I prefer it? Something goes wrong with the 485, you've got a fallback option. Okay. But is it absolutely required? No.
Yeah.
It is not absolutely required. No. Okay.
Correct. Well, in my case, because the next employer is understanding and ready to wait, my fallback is always my current H-1B where I'm employed with this job, the current job. This is only for a future job.
So you don't actually have to join them until you get your green card. Is that what you're saying?
Yes, because they are ready to wait. Basically, they're open-ended since they're looking for a long-term plan, but with because I told that I want with the assurance that they would do the green card. They said that they're fine to not even hire me until the green card comes.
Okay, so what you're saying is you could stay with the current employer and the new employer just does a new green card for you.
Correct. That's what I'm saying.
That's perfect. Yeah, that's
allowed to do direct.
Absolutely. You don't have to have an H-1B for that.
Okay. So yeah, there is no requirement that I have to work for an employer for some H-1B. Although most of the times it ends up being so, it's not required, is what you say.
It is not required. Now I'm going to give you a tip that might help you in future. One of the most difficult things I have ever done as a lawyer is to brief the court or brief somebody about what is going on. So if you had to ask me this question again, simple way to ask it would be, is it required for an employer to process an H-1B if they want to file a green card? And the answer is no.
Correct.
So it's important. No, it's very, very interesting. I used to get yelled at in the Supreme Court every day because I just didn't know how to brief the judges. And the justices were not happy. And that's an art you learn. And so the art of briefing somebody is not easy. Luckily, you guys are IT people. You don't have to brief anybody. People come and brief you, so you are okay. Because when you do requirement gathering, people are coming and briefing you. So it's okay. I mean, but that's just my 2 cents. But yeah, they don't have to file an H-1B. They can go directly into the green card. No problem.
Okay.
One thing.
Usually we are good.
One thing though. You're not allowed to pay even a single penny, either now or in future, towards your pump process. Make sure you're not paying them anything.
Right.
Okay. So that's it.
Right. So that has to be fully sponsored by them.
Absolutely.
The process,
Absolutely. Right. I-140, we don't know for sure. 485, you can pay if you want. In this case, it won't be.
Oh, okay.
Yeah.
Well, I-140 filing fee is only 700, but you're right. The legal fees.
The lawyer's fees too. Yeah.
Yeah.
Okay.
Yeah. But the filing fee is only 700, right?
Yeah. I don't know why. I haven't. The team takes care of all that. So I'm just the resident.
Okay. Okay.
All right. Good luck.
No, I just, yeah. All right. Thank you.
You're welcome. Okay. All right. Last question for the day. I think it's India. Go ahead, sir.
Sir, thanks for taking my question. My name is Vidyasagar.
Ji.
I'm a green card holder.
Mm-hmm.
I have stayed outside the US for in India for more than a year because of COVID-19.
Mm-hmm.
My wife is a green card holder too, and she has a re-entry permit.
Mm-hmm.
And all of my children are US citizens.
Mm-hmm.
And currently, I booked an appointment for a SB1 visa at the New Delhi US Embassy.
Mm-hmm.
They cancelled my appointment because of COVID-19 situation in India.
Mm-hmm.
And currently, the embassy is not taking any appointments.
Okay. So hang on.
May I travel with my family to the US?
Okay. So real quickly, you have a green card already, right? Hello?
Yes, sir. Yes,
You
I do.
already have a green card. Let's look at your
Sir, yes, I do have a green card.
Let's look at your history real quickly. Which year did you get the green card?
Sure, sir.
Which year did you get the green card?
Sir, I got it in 2012.
Okay. Did you live in the
2016? Sorry,
2016. Did you live in the United States after that?
Yes, sir.
Okay.
For 4 years, I lived in the US.
Okay.
I was traveling to India frequently, but I lived in the US.
And
I worked there.
And your family, your wife, everybody lived in USA with you?
No, sir. My family was living in India because of some family reasons.
Okay.
But my wife got her green card in 2018.
Okay.
And she took a re-entry permit before she went back to India.
Okay. Her re-entry permit is now expired?
No, sir. It's valid until September of this year.
Okay. Are you planning to travel before September of this year?
Yes, sir.
Okay.
We are.
When did you leave
And we are planning to travel together.
When did you leave the United States? 2020?
Sir, 2019 December.
Okay. At that point, did you already?
And
Did you get a re-entry permit?
Unfortunately, no, sir.
Okay. So you left December 2020. Okay. And now we are in April.
Yes.
Okay. So that's just about 5-6 months. The question is, if you come back now before September.
No, sir.
Sorry?
Sir, sorry, 1 second.
Uh-huh.
I left the US in 2019.
Oh, 19.
December.
Okay, 1 year, more than
So
1 year.
more than a
Okay.
year.
Okay. So if we
Yes,
go by the normal standards, your green card is gone. That's why you had gone to get SB1 visa. Now the question is, can you travel? And as I told you, the way I read the instructions from the Customs and Border Protection to the air carriers, it appears that people like you should be able to travel, and your fate will be decided at the airport by the Customs and Border Protection. Your wife is in a better situation because she's traveling before September. So
Yes, sir.
she should be allowed to come in. You may want to bring food for both journey in and journey out.
Okay.
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 But see, there is.
Do you think
there
it's
is,
too risky for me to travel, sir?
No, there is. See, you have different kinds of strengths. Your wife has a re-entry permit,
Okay.
but you have a history of staying in the United States for so many years. So who will be able to make it, who will not, it's not something I can tell you. But typically what happens is, and this is also something as I'm talking, it's coming back to me. If somebody shows up at the airport with a green card, the government has to let them in. They can put them in immigration proceedings. They can say, okay, you have to appear before an immigration judge, but I don't think they can keep you out from what I remember the law to be. So should you take a risk? Yeah, why not? I mean, again, what I've suggested to other people, you can go to one of the centers closer to India and see how it plays out. If they allow you in, you're good to go.
Okay.
All right.
Okay. And sir, I have kept all my ties with the US. My car registration, insurance, everything is in good shape.
I can't help you with that
Yeah.
decision because it's really something that will be discussed way down the line. First thing is, can you make it back into the United States? And I think that you should be able to, and they should let you enter the United States. They might put you in immigration proceedings, where I think you could make a case that this was the reason I'm stuck, not because I want to give up my green card. All right?
Okay. Sir, may I ask you a quick follow-up?
You can ask me one quick question. Yeah, go ahead, please.
Sure, sir. Some of my friends said they could even detain you at the
they should not.
the airport.
They should not.
Yeah,
they should not. That's not my understanding.
Okay.
Okay.
Okay. So that's not a risk.
I do not believe so.
Thank you so much, sir.
You're welcome, sir. Good luck to you.
All right. I appreciate it. Thank you.
You're welcome. Hey guys, so I'll run. Good thing we got everything finished. We had plenty of time. So I think this is the right amount of questions. Otherwise it gets too messy. I have to go through the questions too quickly. So I'll see you again in 2 weeks and I'll tell the team to keep down the number of questions. Take care guys. Good talking to all of you. Bye-bye.